some options there to attend at 2 p.m. or 6 p.m. If you want to sign up for that Wills versus Trust seminar, please do so at estateplanninglive.com. So like I said, our topic today is going to be on advanced care directive planning and those documents, just given the timeliness of the fact that this was an awareness day a few days ago on this type of discussion. Just to kind of go through kind of the main documents that you'd want to look for when you're either planning for yourself or planning for a loved one who needs these documents in place if they don't have them already, is when you're talking about advanced care directives, these often include a few different documents, and you might see them compiled in different ways. It really depends on where they're coming from. So oftentimes when our clients come in with documents already, if it's through a hospital or through the doctor's office, they get it in one packet, and that packet is either called advanced care directives, healthcare power of attorney. Sometimes you'll see it referred to as like the 5 wishes, which is just a form power of attorney document. So oftentimes through a healthcare organization, all of these documents are part of one package, but they are separate documents as well. So if you have them separately, that doesn't invalidate anything. It just means you need to be aware of what you have. So to give you a rundown of what these documents are, we have a power of attorney for healthcare is the actual power of attorney document where you're granting the healthcare decision-making authority to somebody. There's a HIPAA authorization, which is granting healthcare access to individuals, information-wise, There's also living wills, which are where you describe what your end-of-life wishes are. So those are the 3 big healthcare documents that you'll have from an attorney side of things, from a legal planning side of things. So to start with the power of attorney for healthcare, there's a couple really important considerations with this document in terms of who you name in this role and what things you want to consider when you are signing this document. So first and foremost, when we're talking about who do you name in this role for a power of attorney for healthcare, first and foremost, this goes across the board for all powers of attorney, but make sure you trust the person you're naming, right? You're granting a lot of authority to somebody under this document in order to make healthcare decisions and potentially also end-of-life decisions. So you want to make sure you trust the person that you're putting in that role, trust them from just a standard trustworthiness standpoint, but also make sure that you trust them to follow your wishes because they will be the ones enacting those wishes. So if it's somebody who you don't think would best enforce your wishes end of life, or maybe do things a little differently than you would, and you have somebody else that you would feel more comfortable having act, that can just tell you who do you name ahead of somebody, right? Who's the first person you would name? Doesn't mean the other person's not a good backup option if that's what you feel is best for your situation. But primary agents, you want to think, who can I trust to be there for me? Who's more accessible to me? Who's likely to go to appointments with me? And who do I trust to follow my wishes first and foremost? So when you're naming this person, a little different than when you're looking at naming like a financial power of attorney, you're also going to be considering location of this individual. Where are they? Because it's harder for somebody to act at a healthcare standpoint if they are, either across the country, they're not going to appointments with you as frequently. If you have 2 people you trust equally to make those decisions and somebody's closer by, that's the person that can be a better fit. Now, if the person who's close by is not a good fit, then you have to be careful about still thinking, well, I'd rather put the person in charge of these decisions who will actually follow my wishes, who is the better person for this. So location is a big factor, but it's not the most important factor when you're naming this person. Then when you're talking to these individuals, when you are naming these individuals, because they are the people who may have to make end-of-life decisions for you, not only is it important for you to have that written down somewhere, but you really want to talk to these individuals as well. Explain verbally what your end-of-life wishes are, because it's one thing to see it written on the living will where you're explaining what those end-of-life wishes would be, but it's a different thing entirely to hear it directly from the person. And that gives you 2 opportunities here. One, to gauge that person's reaction, see, hey, is this something they're really comfortable doing? Maybe they'll tell you they're not comfortable doing it. And that's good for you to know, because if you feel that that is something that they'd be unable to follow through for you, it tells you one of two things. Either you want that person to not act as an agent at all because they're not going to be able to follow through on your wishes, or you want them to willingly resign from that position when the time comes to make that decision. Now, which of those two routes somebody might go with that discussion, it depends on the family and on the individual, right? If you trust that person to resign when need be, then maybe they are the best person still to act before that decision has to be made. But if you think, hey, they wouldn't resign because of a difference in opinion on things, or maybe they have different feelings on end of life decisions, maybe that just tells you that you should name the other person you were considering instead. Now, some people do not have a person to name, right? That's always a concern, especially for maybe single individuals who don't have kids, maybe they don't have close family nearby. So it can be hard to think of who to name in these roles. If you don't have kids, talk to your other close family members if you have those family members, siblings, nieces, nephews, things like that. Maybe close family friends can be an option. People you trust. They don't have to be direct descendants of your direct family, relatives. They can be friends too. It's just somebody you trust. But if you don't have any of those people, there's still options out there. There are companies that act as essentially corporate guardians for individuals if they need somebody to step in for them. And that gives you the opportunity, while you're still healthy, to talk to these people, talk to these organizations, and see whether they're a good fit for you. If you're going to name an entity like this to act as your healthcare decision maker, you'll want to really feel comfortable with who you're acting. So, primarily speaking, if you have an individual in your life who you trust to act in this role, that's by far and away the most important thing to consider when you're naming them. Think about the individuals first before you look at an alternative option like a corporate guardian. They're great options when you need them, but if you have people you trust, you're obviously going to feel more comfortable knowing that they'll follow through on your wishes. So with that document though, there's other considerations that you have, or that you're going to want to discuss with your family when you're going through that. So for example, we often see on the the healthcare powers of attorney from hospitals, from like form powers of attorney, there's a lot of yes and no check boxes. And one of those is very important to consider when you're checking yes or no, and that's whether or not you would want your power of attorney for healthcare to be able to admit you to a long-term care facility if that's what you need. A lot of clients I talk to, a lot of people I talk to say, well, I don't want to go into a nursing home. I don't want to go into assisted living. And that's okay. I don't know of anybody who is saying, well, I can't wait to go into a long-term care facility. Most people want to stay at home as long as possible because that's where they're comfortable. That's where they've lived their life. But when you're checking yes or no on that box, you're not telling that person to, as soon as possible, put you into a care facility. You're just granting that healthcare power of attorney agent the ability to do so when you actually need it. If you mark no on that, that can really not be good for you or for that individual acting as that power of attorney, because it prevents them from, at least initially, getting you into a care facility. They don't have the authority to do that. It doesn't prevent them indefinitely from doing it, however, because they can always petition a court to grant them that authority. So what you're really doing is just making them go through another step, a more restrictive step first, before they can get you the care you need. So when you're filling that out, or when you're having this drafted for you, it's really important to think about that decision and say, is it really that I don't want somebody to be able to do this for me if that's what they really need to do? Or is it that you're just concerned about going into a facility and you don't want that as soon as possible? Or do you really want them to have to jump through that hoop? And I would almost always recommend that you not require somebody to jump through that extra hoop going through a guardianship court to do so, because it is so much more restrictive. It is more work, more expense for them to go through just to get you the care that you actually needed all along. So don't look at that decision as, I can't wait to go to a nursing home, or I want somebody to do this as soon as possible. Think of it more as if it's necessary, can they do this? So with the healthcare power of attorney, I mean, that, especially when we're talking about advanced directives for either later in life or end of life, that is the more important one to look at and think, think long and hard about it and think, is this what I would really want somebody to do, not be able to put me into a nursing home if that's what I need. So most people, I think, that I see mark yes on that because they think about it from the standpoint of, if I really need it, yeah, I'm okay with somebody doing that. But every now and then you'll see somebody that said no. And then if they lose capacity and can't sign a new healthcare power of attorney, updating that decision, that's where that healthcare power of attorney agent may have to petition the guardianship, a court through guardianship, to gain that authority to put somebody into a protective placement or into a nursing home for long-term care. So with the healthcare power of attorney document, it's also very important, once you have filled it out and signed it, that you put it on file at the very least with your primary care physician and the hospital that you're most likely to be admitted to if there's an emergency. So if your primary care physician and your hospital are part of the same health network, often you only need to put it on file with one if they share system, that information online. But if they don't share that information online, or if it is part of a different health network than your primary care physician, make sure you put one copy on file with both. Be very aware, though, that when you sign a healthcare power of attorney, by law, you revoke all of your old prior healthcare power of attorney documents. So part of the reason it's so important to put these on file is so that you're not signing a new one at each place. Because if you do that, whichever one you signed last is going to be the power of attorney for healthcare that's actually in effect. So it does happen from time to time where clients will revoke their prior power of attorney for healthcare accidentally. It's often accidentally, thinking, oh, I just need to get a new one on file here, and not thinking that they're revoking prior powers of attorney. Occasionally you'll run into situations where different organizations will say, well, you need to use our form as opposed to the one you've had drafted for you. And just be aware that that's not true. They can't require you to use their form for a healthcare power of attorney. You have the ability to use the one that you already have. Because if you don't have the ability to sign a new one, they're going to be stuck using that one anyway. So they do not have the ability to tell you have to sign their form in order for it to be effective. You can continue to use your prior power of attorney if that's what you would prefer to do. So only sign a new healthcare power of attorney if you intend to revoke your old ones. Now, the next really important document to have with advanced care directives is a HIPAA authorization. So HIPAA is just the law that says that healthcare providers cannot release your information to third parties without prior authorization. So that's where you sign the HIPAA authorization saying, these are the people or entities I want you to be able to speak to as my healthcare provider. So when you're creating one of these for yourself, it's really important to consider who are the important people in your life that you would want to have access to that information. So first and foremost, anybody who's a healthcare power of attorney or on that healthcare power of attorney document should have access to that information, even if they're a backup, because you don't know if they're going to need to relay that information to the person who is the acting agent. Close family members, if that's what you would like, kids, spouses are important to have on there, extended family members if you really want. But most importantly, the people in your life who are going to act in some role for you, whether that's as a financial power of attorney even, or as a healthcare power of attorney. It's important for them to have access to that information. People often overlook the financial power of attorney agent as somebody to put in this role because they think, well, they only have to deal with finances. But if you think about it, the person dealing with finances might have to know what's going on with your health in order to know what they have to do with your finances. So make sure that just because somebody's not making healthcare decisions for you, that you don't leave them off of that HIPAA authorization without thinking about, well, are they going to really need access to this? Yes, they can get that access through the other authorized individuals, but you'd rather have the people who are in that role just have immediate access to it anyway. So HIPAA, though, is something that many people have already signed numerous times when they go into the doctor, giving them the authority to talk to certain individuals. You don't revoke all prior HIPAA authorizations anytime you sign a new one, so don't be as worried about that. It's really just healthcare powers of attorney and living wills that you don't want to sign new ones if you intend to continue using the ones you had already. So HIPAA does not confer any decision-making authority, by the way. So you don't have to worry about somebody on that list making decisions for you unless they're already on the healthcare power of attorney too. But it's good to have both of those in addition to the living will. So I've alluded to this a few times now that the living will is the document where you're saying, hey, here are my end of life wishes. If I am on life support and I can't recover, here's what I want to happen. Now, this is also a place where you can put in specific end of life requirements for certain religions. Like Catholics have certain requirements end of life. I know Jehovah's Witness clients of ours have certain requirements. So regardless of what your requirements are, regardless of what faith you have, or if you're not religious, I mean, if you have requirements that you need followed at the end of life, this is a document where you can customize those wishes and put that in there. Now, I would be cautious though about being overly restrictive in how those decisions can be made. So what I mean by that is if you're telling somebody, hey, I authorize you to remove me from life support if I'm not able to recover, don't put some arbitrary time frame on there like, please wait 6 weeks to see what happens. The reason for that is because you can actually artificially tie that healthcare power of attorney, their hands behind their back, and that they're not able to make the decision for you that would actually be best in the moment. You don't know what those 6 weeks would look like. You don't know if it's going to be relatively comfortable or you're going to be incredibly uncomfortable or in a lot of pain, right? So if you have specific timing requirements or something more specific about the types of care you want kept or removed, that can be where you want to have the verbal discussion again with that healthcare power of attorney agent to really explain that. You don't want to necessarily put that in the living will because then that's what their instructions are. That's what they have to follow. So the living will, as far as legal documents go, is one of the, I guess, kind of outside of the norm where you'd rather have all these specifics in a lot of legal documents. With a living will, you're generally granting broader authority to say, hey, in general, if I am in a persistent vegetative state, so what most people would think of as a coma, if I'm not going to improve or if I wouldn't have a good quality of life and I'm being artificially maintained, please remove that treatment. However, I ask that you keep me comfortable and free of pain. So that's pretty broad, but that's so that that person has a lot of discretion to make the authority that's best for you at that time. One important distinction is that living wills and DNRs, do not resuscitate orders, are different things. We often have clients who get those confused. I've had a lot of people in my life get confused by those too, because they're very similar things. A living will is the instructions to remove life support from the legal side of things. A DNR, a do not resuscitate order, is saying, hey, if I've stopped breathing, if my heart stopped, don't even try to bring me back. It's not on life support at that point. That would be before that occurs, or maybe if it's not helping. So just be very cautious about getting those two things confused because a DNR is not a living will. And these documents are really important to have: living wills, HIPAA authorizations, healthcare powers of attorney. Regardless of age, as long as somebody's 18, they should have these documents on file or in place for themselves, because once somebody's 18, the law does not assume that anybody can make decisions for them anymore. So having these in place, those three in place, not the DNR, but the living will, HIPAA, and healthcare power of attorney, is really important for any legal adult because they may need somebody to make decisions for them. So just to give you an example, whereas I don't expect to be on life support anytime soon, I have a living will that says, hey, if I'm not going to recover, please don't keep me that way. Now, no doctor in the world with my current health, I shouldn't say no, but most doctors would probably not grant me a DNR because I would likely have a good quality of life if I were to recover. So a DNR tends to be for people who it would cause them more harm than good to resuscitate them, to try to bring them back. A living will is the other side of that coin, saying, hey, regardless of whether or not I have a DNR order, if I can't get better and I'm on a feeding tube, on a ventilator, please don't keep me that way. So they are different things. And like, I can't give somebody a DNR. That has to come from a physician. I can't be the one doing that. And the living will is the other side of that coin, where it's an attorney creating that for the client. So very similar. I can understand why people get confused on that, but just know that they are different things and they come to play at different times as well. So what happens if you don't have these documents, though? That can be a really, really concerning thing. Because if you don't have these documents in place, or your loved one doesn't, and they lose capacity and can't sign new ones, the concern is that the only way to get some of these authorities then to make healthcare decisions, to make end-of-life decisions, would be petitioning the court for guardianship over that individual. And it's not that guardianship is always a bad thing. There can be perfectly valid uses for it, especially if somebody has a child with supplemental or special needs that they need to continue on guardianship over them after they're a legal adult. That can be a perfectly valid time for that. But for most people, if you don't need a guardian because you otherwise have capacity, you don't have any of those like special circumstances that would require a guardian, you can grant all of the same authorities that the guardianship court would grant you, or grant that individual over you, by having a well-drafted power of attorney document, by having a living will and having a HIPAA authorization. So you can avoid an expensive court process if you have these documents in place already. And that's also where I was talking about that decision on admission to a nursing home, is if you have gone through the effort of putting all of these documents in place and you would have otherwise avoided the need for guardianship because you've already granted all these authorities, don't have that be the one reason that your family member needs to go through guardianship, just to admit you to a nursing home, later on, because that's what's actually best for you at that time. So think about that when you're filling that out. If you have that form and you see that you've marked no on it, for that decision, think about maybe whether or not you want to change that. I'm not directing you one way or the other on that. It is a personal decision, but it's an important one to know what the full consequence of that decision can be, because it's not as clear cut as they'll never be able to put me into a nursing home then. They still can. It just requires a lot more expense and time than it would have otherwise. And that's not necessarily better for you either. It still has to be what's best for you in these decisions. Having these documents in place too also releases a lot of the people who make decisions regarding your healthcare. If they're named in these documents, it releases them from a lot of liability for making these decisions. So one of the biggest things you'll see on a living will with removal of life support, for example, is the person enacting my wishes to the best of their ability does not have any liability for making that decision. So if there are concerns about certain family members having a problem with that decision, they can't go after that person for just enacting what your wishes were. So it's really important to talk with as many people in the family as possible about what your wishes are, so everyone's on the same page, especially anybody who is actually listed on that healthcare power of attorney document, and could have to make those decisions. So I'm not seeing any questions on this or on anything I've brought up yet. I'll just go through again a couple reminders, but you'll at the end of this webinar, you'll receive a couple of things from us. You'll receive our 4 key documents, which talks about the financial power of attorney as well, but the 3 other documents, healthcare power of attorney, HIPAA, and living will that I've talked about today, those are outlined on that document as well. So you'll receive that via email. And then you'll also receive a feedback form from us, which of course gives you a place to give feedback, but also allows you to tell us that you'd like us to reach out to you and set aside time for an initial consultation. Our initial consultations are complimentary. They don't cost you anything to come in and talk to us. We do schedule them for about 2 hours. So to give us plenty of time to not just talk about these documents that I brought up today, but also, other estate planning documents, wills, trusts, whatever you have already or need to get in place as well. And then next week, our topic that we're talking about, same time, is actually on understanding Medicaid eligibility. So Medicaid in relation to nursing home planning, or worrying about paying for nursing home costs, Medicaid planning is a very common thing to discuss when a loved one is about to go into care, or when someone's concerned about going into care at some point in the future. And the rules around Medicaid eligibility can be really confusing. So it's a really helpful thing to kind of hear a rundown on what that actually looks like for somebody, whether they're single or married. Then the week after that, we're off. We won't be having a webinar the following week after that. So 2 weeks from now, we won't. And then the week after that, we'll actually be doing our in-person Wills versus Trust public seminar in Green Bay at the Green Bay Public Museum, the Neville, at 2 p.m. and 6 p.m. So if you want to sign up for that, you can do so at estateplanninglive.com. And I'm still not seeing any questions, so I will wish you guys a good rest of your day and hope to see you guys